All right, it is a Thursday morning, the 24th of October. The year 2024 continues to bring in the historic year in Kenyan history. We are talking about the second serving deputy president since the promulgation of the 2010 Constitution, now facing impeachment. If you followed closely, number of legal voices are not at par in as far as interpretation of orders that are so far now before the High Court are concerned. We'll get deeper into that. Welcome to KTN. This is the special coverage of the date with the courts. We have seen quite a number of submissions, especially yesterday. And what we have been doing here is not just bringing you the coverage, but going further to analyze what exactly the impact would be on you as a Kenyan and on the governance of this particular country. My name is Anki Dorisombat. We are up and running on social media. You can find us at KTN News KE on X. You can also find me at Doris Anki on X. Make sure, as you engage with us in the conversations today, you tag us through it all, share your opinions, and also your expectations in and within the corridors of justice. Let me give you a bit of the history to how we got here. Now, first, before I do that, let's just take a look at the front page of the Bold newspaper that I'm holding right now. That is the Standard. And the paper today will read this and reads this: blow to Gachagua as judges stay put. Bench composition was a concern, especially yesterday, and this was looked at. And fresh from blows in the National Assembly, the Senate, and the courts last week, impeached deputy president's attempt to block a three-judge bench set up by Deputy CJ Philomena Mwilu to hear the impeachment cases fell apart, with judges dressing down lawyers for their conduct during hearing of the application. We're seeing there the three judges, of course, their faces right next to that of the impeached deputy president, Justice Eric Ogola, Justice Anthony Mrima, and Justice Freda Mugambi. These are the particular judges that make up this three-judge bench that was challenged by the deputy president's legal team and as far as its composition is concerned. And I will quote what the High Court judge, that is Justice Anthony Mrima, said, among other things, and I quote, "On our part, we have carefully considered the issue. The drafters of the Constitution had a reason to have the DCJ deputize the CJ, that is the Chief Justice in the Supreme Court, and not in the Judicial Service Commission." Now, as we continue to look at this front page, I will also give you the happenings yesterday and in their arguments and submissions yesterday on why this particular three-judge bench should be able to proceed even today, is that the DCJ is allowed to take up administrative roles in her position, including then putting together this bench that was challenged earlier on. But overhaul calls as Moi Varsity fights for survival on page 8. You will see the details that troubled institution requires financial bailouts, robust reforms in governance and leadership, even as reopening date remains hazy. And junior starlets pick lessons from World Cup on Matter Sports is on page 46, and on the world page 24, we're looking at the international news. And Kamala Harris says U.S. ready for woman president, and as far as the U.S. polls are concerned. But what next has been covered on the page 2 of the Bold newspaper today. The address growing unrest among the youth in sub-Saharan African countries. The International Monetary Fund, IMF, wants Kenya and other nations in the continent to prioritize job creation and has identified the 3 major challenges that it says must be addressed to improve job prospects. Well, that's it for the front page of the Standard. But again, we keep our eyes on the front page main story: blow to Gachagua as judges stay put. Now, we are expecting to sit down with the former LSK president, that is the Law Society of Kenya, President Eric Theuri, shortly. And in this particular engagement, we will be still looking at what legal issues could be coming up today. If you followed last week, a number of orders surfaced, and it was important then to also mention to you that this particular date was officially placed in for a hearing this week, but there was a bit of confusion on how many petitions were being brought in before this three-judge bench. There was what happened on 22nd of October that got us to this point in time. The challenging of the bench sitting or being empaneled on a Saturday. All this timing issues around the constitution and legalities arose, and we also have understood that different arguments, according to legal voices, were suiting the sides which these particular lawyers were representing, saying a lawyer has to win a case. So regardless, they are doing their arguments to also not just suit their clients' positive win, but also to align with the Constitution, and you know that the Constitution remains supreme. Stay with us, because I'm awaiting then Eric Theuri to join us shortly to give you further analysis and from the lens of an expert, legal and brilliant mind. But even as we do that, we are live on Facebook as well, so you can search KTN and drop a comment there. And of course, I'll ask you, do you have confidence in the courts? That would be one question. The impartiality nature of the corridors of justice. What is your opinion as far as the impeachment case of Gachagua is concerned this far? But it's a very big day. Generally, it's a very big day in Kenya. And we are then going to follow as well with our reporter on the ground, who is just but putting things in order, and will join us live from those particular courts in a very short while, some would say in a jiffy. Let's take a recap of the stories last evening, just to, of course, bring you closer home. A three-judge bench of the High Court has ruled that Deputy Chief Justice Philomena Mwilu carried out her duties by empaneling a bench to hear cases challenging the impeachment of Rigathi Gachagua as Deputy President. Justices Eric Ogola, Freda Mugambi, and Anthony Murima ruled that they were correctly appointed to handle Gachagua's cases. The judges will today morning hear submissions of the consolidation of the various cases challenging the ouster, and in the afternoon they will hear an application for the recusal from the case.
Impeached Deputy President Rigathi Gachagua today suffered a blow after his application challenging the empanelment of a three-judge High Court bench to hear cases challenging his ouster was dismissed with costs.
We do find and hold that the accusations made by the applicants against this bench are entirely without merit.
The application dated 22nd of October 2024 is disallowed with costs in the course. Leave to appeal is hereby granted. Certified copies of these proceedings and rulings shall be availed upon payment of the requisite court fees as the case may be. That's the ruling of the court.
The judges in their ruling said that Deputy Chief Justice Philomena Mwilu carried out her duties as Mother Kome's deputy to empanel them to hear the cases, as Kome had already chosen them to hear cases that were filed while the impeachment process was ongoing.
For this reason, the functions of Article 165, sub-Article 4, in our view, and in as far as the same relate to the office of the Chief Justice, also includes the Deputy Chief Justice acting in the capacity of the office of the Chief Justice or discharging its functions in an interim, acting or auxiliary role.
The judges, however, did not answer the question of what difficulties Chief Justice Koome faced that made it impossible for her to empanel the bench.
For the Deputy President, not former. He remains in office on the basis of the conservatory orders, and each bench has confirmed weighty issues, which is why we are here.
The consolidation should not then slow down the hearing of the application that you have already identified as that. If they are to come on board, they come on board and proceed from where we are.
I would like the court to give directions bearing in mind that the stakes of the parties, all the people who have filed petitions, is to ensure you are not faced with a fait accompli, where you are told we have already sworn Kindiki and you can go to hell. We do not want to be faced with a fait accompli situations.
On Thursday morning, the three judges will hear submissions on the consolidation of different files challenging Gachagua's ouster, and in the afternoon hear an application for their recusal from the case. Fred Kagonye, KTN, Nairobi.
Now, what next after the ruling is a major question. It is now apparent that Deputy President-designate Professor Abraham Kithure Kindiki may wait a little longer to officially assume office. The legal battles could as well proceed to the apex court, the Supreme Court, going by some of their sentiments. Now, with yesterday's ruling that the three-judge bench will hear the Gachagua impeachment case, Grace Nganga reports that the contest has just begun.
Although allies of President William Ruto were sure of getting Abraham Kithure Kindiki in office as second in command as early as last week,
Professor na nitakuwa live. Na nitakuwa live pia.
And as late as yesterday,
tunamalizana na hiyo maneno Tuesday by saa 4 atakuwa ameweka Biblia chini. Na tuseme tafadhali. Na hatukufanya kwa sababu ya tafadhali.
Kenyans will wait longer until they have a substantive deputy president following the impeachment of Rigathi Gachagua and the ongoing legal battles to salvage his career, fortune and reputation. After Gachagua lost his bid to challenge the empanelment of three judges to hear and determine their cases, they still have a leeway of dragging the case by appealing the case to the higher courts.
If only for the purposes of everybody getting sufficient oxygen. Because we are too crowded and the people want to listen, and the media and the members of the public. If it is possible, let us use the ceremonial hall.
We are being made orphans. The state is in the bedroom. Let us also be in the bedroom so that we can respond.
Already, President William Ruto's lawyer, Adrian Kamotho, has hinted that he may want the case to be handled by the Supreme Court. With a three-judge bench ruling that they were properly constituted, they will go ahead to listen and determine the impeachment cases, some of them already consolidated. These as questions continue to linger on whether Kindiki is still CS Interior National Coordination after he failed to appear before a Senate committee today. This was, however, attributed to the ongoing political developments in the country. Some of the issues Gachagua is opposing in the appointment of Kindiki is the role of IEBC in the process, which is currently not properly constituted, and his denial to fair trial, among others. Grace Nganga, KTN News, Nairobi.
Indeed, thank you very much, Grace Nganga. And all eyes are on DP designate or nominee Kithure Kindiki. And Interior CS, Professor Kithure Kindiki, who is also the Deputy President designate, failed to appear before the Senate yesterday morning, where he was supposed to respond to questions from senators concerning his docket as the CS. While the communication from his office did not state the reasons for his failure to appear, analysts argue it could be a result of the current confusion regarding which position he holds. Well, we also look at the rise of Professor Kithure Kindiki, the man poised to become Kenya's third deputy president following the impeachment of Rigathi Gachagua.
The Senate had on Wednesday anticipated having a session with the Interior CS Kithure Kindiki, also the deputy president nominee. Kindiki was expected to appear before the senators to respond to some questions about his portfolio. Kindiki, however, sent an apology, regretting inconvenience caused to the Senate.
We were supposed to have two cabinet secretaries this morning, the Cabinet Secretary for Interior and National Administration and the Cabinet Secretary for Energy. We have since received communication. Indeed, yesterday the SBC did take a position with regards to the communication from the Office of the CS, Interior and National Administration, that excused him. And this is the wording of the letter that was received. The Cabinet Secretary for Interior and National Administration is not in a position to honor the invitation, and all inconveniences are highly regretted.
But even as he failed to appear before the Senate, Professor Kithure Kindiki is a man to watch as he inches a step closer to achieving a dream that was stopped in 2022.
How are you?
He was one of the two persons Ruto was set to pick as his running mate following rigorous vetting process in 2022. In the run-up to the general election, members of parliament from Mount Kenya allied to William Ruto, who was then the UDA's presidential candidate, recommended to him the person who will be his running mate. A vetting committee was established and tasked with coming up with a name of a person who would suitably serve as Ruto's running mate. The committee settled on the current Interior CS, who was then serving as the senator for Tharaka Nithi County. However, the president in his wisdom picked Rigathi Gachagua, the first-term member of parliament for Mathare constituency, and later appointed Kindiki as Interior CS after he won the presidency. Following the impeachment of Rigathi Gachagua as Kenya's second-in-command, the president nominated Kithure Kindiki as Gachagua's successor and forwarded his name to the National Assembly, which on Friday last week unanimously approved his nomination. Born 52 years ago in Irunduni village in the semi-arid Tharaka Nithi County, Kindiki attended Irunduni Primary School and Lenana School before pursuing law at the University of Nairobi. Kindiki served as the senator for Tharaka Nithi County, majority leader and deputy speaker of the Senate between 2013 and 2022 before he exited elective politics. His friendship with President William Ruto dates back to the time when he was appointed to be part of his legal team in the ICC proceedings in The Hague over crimes against humanity after the 2007 general election. Before joining politics, he had an illustrious public service career in the academic sector where he served for over 11 years. He has risen the ranks from an assistant lecturer at the Moi University School of Law to now just about to be confirmed as the second in command if the High Court upholds the impeachment of Rigathi Gachagua. Clement Masombo, KTN News.
Well, those are the major happenings yesterday, and we also want to appreciate your feedback on our social media platforms. Thank you very much for engaging KTN throughout these conversations. But once again, as we are then going to be engaging the former LSK president, Eric Veuri, shortly on this conversation, and as we await, of course, the latest on the location by a reporter, let me once again bring the front page of the Bold newspaper to you. Blow to Gachagua as judges stay put. The bench composition was one of the key issues raised on these petitions, but now it's fresh blows from in the National Assembly, the Senate and the courts last week. Impeached Deputy President's attempt to block a 3-judge bench set up by Deputy CJ Philomena Mwilu to hear impeachment cases fell apart, with judges dressing down lawyers for their conduct during the hearing of the application. You'll see more of those, of course, details on page 4 of that paper, including the major issues that have been highlighted. Does the Deputy CJ, that is Chief Justice Philomena Mwilu, have the powers to empanel a bench? Another question that arose and an issue is, did the Chief Justice Martha Koome delegate powers to Mwilu? However, you understood, if you followed closely, the judges giving their submissions on the matter, even as they said they understood the prayers beforehand, is that it is in her jurisdiction to actually be able to then constitute this panel, or pretty much judges. When and how 2 files from Kerugoya got to the Deputy Chief Justice was another issue, but we will also engage the lawyer and advocate on this matter. The other issue was there a written notice to advocates that the bench had been empaneled. We heard from different advocates during the litigation questioning why they sat on Saturday, why they were not engaged in the times that the cases would be picking up and the petitions, etc. But I'm not a legal voice, really. We are yet to hear from an expert shortly. Another issue that arose in this matter now before the courts is, did Justices Eric Ogola, Fred Mugambi, and Anthony Mrima sit on Saturday? I just mentioned that. That also was made clear. For those who are not very satisfied with that, we can again engage Wakili Theory. And orders for parties to appear on the October 22nd instead of October 24th, as I mentioned earlier on, and I believe it is Kibe, Wakili Kibe, that boldly brought this up, this argument, as had been initially directed by Justices Chacha Mwita and Richard Mwongo. A lot of questions are arising in how the judiciary is acting or behaving at this point in time. Remember, the impeached deputy president, Rigathi Gachagua, had also, said that, and according to his legal team, that they didn't have very much confidence in this 3-judge bench, citing bias. And these are some of the issues that surrounded their concern or reservations. But I will continue to engage you as well on our social media platforms. In fact, we have some of your feedback that have been streaming in since we started these conversations on, KTN. There are questions of, is President William Ruto having a hand in this? Is the judiciary truly impartial? Or is executive going to be winning over through politics? I can see here there is Sami Olekabu, who sent, one of the feedbacks asking what happens. Do we liken the case of the deputy president to cases of deputy governors? Because we've seen a number of impeachments as well. But also someone's asking, what's the difference then in impeaching a deputy governor and impeaching a deputy president? But let me also make it clear that this is the first time that Kenya is going through something like this in terms of deputy president impeachment, or somebody in this kind of office acting in this kind of capacity. Where does this leave us? There is no precedent set in as far as creativity or judgment is concerned. So we'll hear from Eric as well where this leaves the courts. All right. Is there any parallel case to look at? There are concerns on the global acceptance of the place of the courts in as far as the impeachment of a deputy president is concerned. All right. Now I want to engage the expert, but once again, I'm encouraging you to keep sending us your feedback and your questions. I know there's somebody writing here, there's confusion brought about the copy-pasting of the 2010 Constitution. Was it copy-pasted? I want to hear from Eric Theory as well. There are questions here of, are we having a concern around deputizing a head of state in the country? And what is the end game? Another question that has also come here from the Kenyans is, does Kithure Kindiki now fall in as a deputy president designate? Has he started then serving in that capacity? And why didn't he then appear before the Senate? Is this bringing a confusion in his roles? Well, good morning. This is KTN, and let us now hear from Eric Theory, who is the former LSK president, that is the Law Society of Kenya. He's also an advocate. Wakili, it must have been quite engaging yesterday. Karibu to the studios. Good morning.
Good morning. Thank you for inviting me.
Karibu sana.
Yes.
Kenyans are eagerly waiting for the day and how it will turn out.
Well, I can understand the anxiety, the intrigue that have surrounded this case. Mm-hmm. We saw from the first 2 days the very robust arguments that were advanced by the various parties in these proceedings. And you must remember that we have so many cases, we have so many lawyers, and so it's going to be an intense period of legal work, legal drama, so to speak.
Okay.
But ultimately, we expect that the courts would be able then to condense all those arguments and apply their minds to it and come up with a resolution of the issues that are before the court, because that is what the judges are required to do.
I want to go back to the empanelment, but before I do that, you have mentioned that there are so many cases and so many lawyers. Indeed, we've even seen the AG being represented at this point in time. They keep growing, and as far as some of us are concerned. But what happened to the consolidation? And as far as I am informed, these cases have so far been consolidated, because earlier on we had over 30 petitions, but in this particular two cases of 22nd October and 24th, and what has been highlighted mostly is that we have two major cases right now before the three-judge bench. Perhaps you could clarify what exactly we're looking at today, and we shall proceed from there.
Okay, we can say there are two major cases. We are saying two major in the sense that they have certain interim orders. And it is those interim conservatory orders that have prevented the deputy president designate from getting into office. And naturally, the advocates, the Attorney General and advocates acting for the state, are eager to vacate those orders so that the deputy president designate can take office. Those that are acting for the petitioners who have presented those cases and who have those orders in place are trying everything possible to ensure that those orders are not vacated. So that is the contest. So that is why people can say there are ideally like two major cases.
All right.
But you see, there are a myriad of cases. There are quite a number of cases that have been filed on this issue. And those that were filed, particularly after the impeachment, fall in the same category as those who do not have, those who have the orders, because they would be saying that if this case proceeds and the interim orders are not there, and the deputy president designate gets into office, then their petition would sort of become an academic exercise.
Is that what they're calling, I don't know if the term is correct, something like a fait accompli?
Yes,
situation?
In essence, that would be it. It will be an exercise perhaps in futility. And I say this perhaps for those that are not so directly affected, because for the deputy president, he still has something in this fight, irrespective of whether the orders are vacated or not.
What do you mean? What do you mean he still has something?
I mean, because the way I'm looking at it is that if this case is hard and determined, the court may eventually find that the process of impeachment did not meet the constitutional threshold. And I think that is what his main prayer before the court is. So that his argument would be that if I am replaced, then if the court determines that question, I would have been then subjected to a constitutional process and suffered damages or suffered as a result of being subjected to a constitutional process and being removed illegally. So that would be his argument. And so he would be asking the court, preserve me in office until when you determine this case, so that if you find that I was removed unconstitutionally, then I can exit the office. But if you find that my removal was unconstitutional, then I do not suffer. I continue acting. acting in office.
Now, so that you don't lose us, Wakili. So you're saying that we have these two main cases. It's not like we don't have the others, but in as far as vacating certain orders are concerned, and you have said that there is then a possibility, all right, that there are certain orders that if vacated would allow the designated, all right, DP to take oath of office, or certain orders, if vacated, would allow the now impeached deputy president to stay in office as we continue with the process in the corridors of justice to clear the argument around the process, is it?
Okay, now, so here's the factual situation.
All right.
DP Gachagua has been removed from office.
Constitutionally, he's
Constitutionally, he is out.
Okay.
Because as it stands right now, the declaration by the Senate has not been reversed by the court. Now, there will be a lot of arguments around whether the court actually has the power to vacate that decision or to declare it unconstitutional and so therefore of no effect. But that is the factual position as we stand. The second position is that following the impeachment and removal, and you have to remember that the Constitution says that the deputy president or the president can be removed from office through impeachment. So that's very critical, that we must understand that the DP Gachagua has been removed from office as a result of impeachment.
All right.
Then, after his impeachment, Professor Kiki was appointed, was nominated. He went to Parliament, and he was approved in Parliament as required under the Constitution.
His name went before the Parliament?
So he went to Parliament, he was cleared in Parliament. He was voted for in Parliament as required under the Constitution. There might be questions around that, and those questions are still before the court. But that is the factual position. So the first thing that we need to ask ourselves, and this is what is going to play out before the court, there are certain positions that require certainty. They require certainty because they have consequences. There might be an argument as to who got us into those consequences, but they are almost not so important as the fact that there are consequences. And what is the consequence here? Is that the deputy president is the principal assistant and the president designate in the event something happens to the president. So, and that's why we're saying we need certainty, because what we know is that in the case, for example, of the judiciary, if the Chief Justice, Martha Koome, is not there, there is a deputy who will exercise that function.
All right.
So the question right now is, if the president is not there today, who assumes his office?
There's arguments that we have the speaker that would be there for about 60 days running a few things.
And that's why I'm saying that the bigger question that the court is addressing is that question of certainty.
All right.
Ultimately, whatever arguments that will be made before the court, the one thing that the court is looking at is how can we be able to address this situation and give certainty to the country in the sense of who is the deputy president. Because if you ask the question of who is the deputy president in this country now, you can get three answers.
All right.
The three answers is that's Rigathi Gachagua, it's Professor Kiki, and the third answer is that it depends.
It depends.
On how you decide to interpret the position.
Okay.
So I'm looking at it and I'm saying that what you will see before the court would be the court attempting to go through so many issues. There are so many issues that are likely to come out. The first issue in terms of whether the DCJ can actually constitute a bench has been dealt with.
That has been dealt with.
That has been dealt with. But there are other questions. You have seen other preliminary questions that will come into play. As we have said, there are just not two cases. There are only two conservatory orders, which every party is trying to ensure they are removed so that the deputy president designate can be sworn in, and others are trying to ensure are not discharged so that we remain in this position until after the court has made a determination. So that's the factual position, and you will see that the court will be attempting to get to hear the main arguments as to whether or not those interim orders should remain or they should be confirmed pending the hearing and determination of this case. But my suspicion is that there are so many other preliminary questions that are coming in, and some of them even would relate to whether, for example, officers who are state officers can actually come to represent institutions like Parliament, the Attorney General in these proceedings. All those are interim issues which the court will have to clear the way they have cleared with the question of the setting up of the panels. So they have to clear all those preliminary questions and get to the main hearing, or they can decide to condense all those preliminary issues together with the hearing of this application so that the country can have certainty in terms of the question of who is our deputy president.
Now, you've brought in another very key concern, and I just want to quote the lawyer Kibe Mugai when he was talking about the preference or prejudice or bias towards the executive, because you've mentioned the state officers. And he asked some questions. He claimed that, and I quote, the court was giving the executive special treatment that was condoned by the 1963 Constitution. That was his argument. I'm just, in hindsight. And in this, he was speaking about the applications filed by the AG, Dorcas Oduor, in the National Assembly, according to Kibe, were fast-tracked to Tuesday, while they were initially required to be mentioned on Thursday, that is today, this week. Now, in as far as some lawyer submissions are concerned, and the concern that there's some special treatment in as far as this particular, I know there are two main cases, because one came, of course, from the National Assembly, and that they were fast-tracked. Is this going then to interfere with how we're going to see the judges, though they tried to clear and said they were very impartial, but Kenyans are watching, and there's something that has been raised. So is it then going to affect some sort of trust and confidence in how will the judges ensure that how they behave henceforth does not seem to be leaning towards the executive? And were they wrong then, or is Kibe right in his submission?
It's a very delicate balancing situation.
All right.
And as we have informed you earlier, look at it from the position of the deputy president. If there is an attempt for his removal, of course, before the interim orders were given, the deputy president would have wanted his case to be heard as fast as is possible. Even if it was to be heard on a Sunday, even if it was to be heard on he would have wanted it as fast as possible, because at that point, his life, his political career was at stake. As it stands right now, he has a reprieve, he has a temporary reprieve, and he is comfortable. So you have to juxtapose that with the position that the state is finding itself in.
All right.
The state is finding itself in a position where it cannot wake up and say, if something happens to the president, we know what will happen tomorrow. Because if something were to happen to the president, then something will have to give. Something will have to give. It will either be some discussion or something, so that either you now say the resolution of Senate is hereby set aside so that Rigathi can assume office as the president, or there is the order suspending what Kindiki is done away with, so that Kindiki then is sworn in as the president of the country. So is that, if you ask me, that is a very weighty question, because we all understand the place and prestige the office of the president enjoys. And you have seen in so many other countries that the decision of who the president is determines so many other things. In fact, even whether investors would want to come to the country, they want to look at who is the president and what are his policies and so many other things. So the question, the element of uncertainty in government, even for one day, in terms of if something were to happen, what do we do? Although it is not to say that there are no legal solutions to that.
All right. It will be such a tense moment in this country that we don't know who is going to be the president. Yet we have one person designated and we have another person removed from office, but the implementation of his removal has been stopped. So it is. If you look at it, you see that you can understand why the state is also in the same position as Rigathi Gachagua was before his impeachment was, before an order, a temporary order stopping his removal was done. Because if the temporary order had not been given, Kindiki would have been sworn in. So for the lawyers, if I am representing the deputy president, I must ensure that the orders are sustained. If I am representing the executive, I must ensure that these orders are discharged. The court finds itself in that place. Of course, in this instance, because of the heightened political pressure, the focus and attention is squarely on the court. Squarely on the court, and I agree with you on that. When we come back after this break, we'll be looking at what you termed, Eric Theory, in an earlier interview somewhere else, that we're in a very difficult situation. And why? You said, number one, we don't have an IEBC properly constituted, and you said it's just a very thin line, and you've mentioned a bit of it. We might find ourselves in a constitutional crisis, or a bit of it. But you also said we don't have a legislation around the impeachment of a deputy president. What exactly did you mean? We come back with that conversation after this short break.